Okay, so today we're diving into something pretty crucial for anyone running a hotel in South Africa.
Uh-huh.
And that's how you handle all that guest data you've got. And obviously, the big elephant in the room, or should I say the lion in the bush, is POPIA, the Protection of Personal Information Act.
Right. Yeah, no hotel can ignore that these days.
Exactly. And we're going deep on this one, especially for all you hotel managers and management groups out there. You're trying to give those amazing guest experiences and keep things running smoothly. But then there's all these data regulations to navigate.
It's a real balancing act for sure.
Absolutely. So we're not just here to decode all the legal jargon. We actually want to show you how getting on board with POPIA isn't just about checking boxes for compliance. It can actually be a smart move to streamline your whole operation and, honestly, avoid some serious headaches down the road.
I think that's something that often gets missed. It's not just a burden, it's an opportunity.
Right, an opportunity. And where we're digging for this info is right in the POPIA Act itself, straight from the source.
The best place to start.
So, when we talk about POPUR, it's not just some abstract legal thing, right? It's actually deeply connected to something really fundamental in South Africa.
Absolutely. The right to privacy.
Exactly.
And that's enshrined in the Constitution, Section 14. And POPIA itself, right in the preamble, the very first lines, acknowledge this right. It's like the foundation.
Yeah. So for your guests, this isn't just like a nice to have, it's a constitutional right to be protected from anyone collecting, storing, sharing, or using their personal information in a way that's not allowed.
Huge implications, really.
It does. And that's where POPIA comes in.
Right. The whole point of POPIA, as it says in the preamble in Section 2, is to put some rules in place around how both public and private organizations handle personal information.
So that includes hotels, right?
Obviously, yes. And this isn't just some South African thing either. This brings South Africa in line with how data protection is handled globally.
Okay, that makes sense. But POPIA, it's not just about locking down all information completely. It's trying to strike a balance.
Oh, for sure. It's about giving people rights over their data, but also recognizing that sometimes there are valid reasons to limit those rights a bit.
Right.
Well, think about it. Sometimes you need information to flow freely, for things to work, for businesses to operate. So POPIA tries to balance individual rights with those broader needs.
Okay, so there's nuance to it. It's not just black and white.
Exactly. And to really get how POPIA affects what you do every day at your hotel, we need to get clear on some key terms.
Yeah.
And these are all defined right in Section 1 of the Act.
All right, let's break it down. Let's start with the most basic one, personal information. What actually falls under that umbrella in, say, a hotel setting?
Okay, so think broad here. We're talking race, gender, contact details. So phone numbers, email addresses, physical addresses, all that's in. If your hotel happens to collect it, location data from, say, a guest's phone would fall under personal information too.
Huh.
And then there's all the online stuff. IP addresses, those little website cookies that track people, those count. And here's something people might not immediately think of. Guest feedback or opinions. Those also fall under personal information. And then there's the most obvious one, a guest's name. Especially when it's linked to other info, or even on its own if it could be used to identify someone or reveal something personal about them. Basically, if a piece of information can be used to single out an individual, it's probably personal information under POPIA.
So it's pretty comprehensive. Any exceptions?
There is one important one, information about people who've been deceased for more than 20 years. That's specifically excluded.
All right, good to know. Now, there's another term, processing. Sounds kind of technical.
It does, but POPIA defines it really broadly. Basically, any action you do with personal information is considered processing, whether it's done automatically, like through your property management system, or manually if you've got paper records, as long as those records are part of a filing system, organized somehow. So this includes collecting information when someone books a room, storing it, organizing it, updating it if a guest comes back, using it for check-in or billing, even sharing booking details with, say, an online travel agency. That's processing.
And getting rid of information, that's processing too, right?
Exactly. Deleting it, destroying it securely so it can't be recovered, all part of processing. Basically, any touch point you have with guest data, from the second they book to the moment their data is gone, you got to think about POPIA.
Okay, so processing is pretty much anything you do with that data. Important for hotel managers to grasp that.
It is. Now, who's calling the shots when it comes to all this? That's where the responsible party comes in.
And who would that be in a hotel?
The hotel itself. You, the management, the owners, you're the ones who decide why and how that personal information is going to be used. You're the responsible party.
And the guest is the data subject.
Exactly. The person whose information you're handling. And sometimes you need their permission to do certain things with their data. That's where consent comes in.
Okay, so what does proper consent look like under POPIA?
It has to be freely given, no pressure. It has to be specific to what you're doing with the data, and the guest needs to understand what they're agreeing to. No hiding in the fine print.
Right, that makes sense. Now, hotels often work with other companies, third-party service providers. Where do they fit into all of this?
They're usually considered operators. An operator processes information on your behalf based on a contract, but they're not your employee. Think of your booking system provider or the company that manages your Wi-Fi.
Okay, so they're handling data, but the hotel is still ultimately responsible.
Exactly. And you need to make sure your contracts with them have all the right safeguards in place. Speaking of safeguards, let's talk about the information officer. That's a role we hear a lot about in relation to POPIA.
Yeah, what does that person actually do in a hotel?
So for a private company like a hotel, the information officer is basically the head honcho, as defined by another law, the Promotion of Access to Information Act, or PAIA. POPIA just borrows that definition. They're the data privacy champion, making sure everything aligns with POPIA, a big responsibility.
Okay, so they're the go-to person for all things data privacy. Now, I'm sure some people listening are wondering, does this even apply to me? Who exactly does POPIA cover?
That's clarified in Section 3. It applies to any processing of personal information that's recorded by or for the hotel.
By recorded, you mean?
Could be electronic systems like your PMS or online booking platforms.
Yeah.
But it also covers manual records, as long as they're part of a filing system. Like if you've got guest details filed away in a cabinet. And the big one,
Mm-hmm.
the hotel has to be based in South Africa for POPIA to apply.
Okay, so if your hotel's here in South Africa, POPIA is the law of the land when it comes to guest data. No two ways about it.
Now, the heart of POPIA, the stuff every hotel needs to build its data practices on, are the 8 conditions for lawful processing. They're all laid out in Section 4. These are like your core principles, not just a checklist.
Okay, I'm ready to dive in. Let's hear them.
All right. So we've got accountability, processing limitation, purpose specification, further processing limitation, information quality, openness, security safeguards, and data subject participation. 8 pillars of good data governance right there.
We're definitely going to unpack each of those, but first, are there ever times when these conditions don't apply?
There are some exceptions, yeah. Section 6 and 7 outline those. For example, POPIA doesn't apply if you're just handling personal information for your own stuff at home, like personal diaries or family photo albums. It doesn't apply to information that's been de-identified either, so it can't be linked back to a specific person. And there are some exceptions for things like national security and public safety, but those probably won't affect most hotels.
Yeah, that makes sense. So, unless you're running a spy hotel, those exceptions probably don't apply.
Right. Now, what about marketing? Hotels do a lot of that, and it often involves personal data.
Yeah, how does POPIA handle that?
Well, direct marketing is specifically addressed in Section 4.6,
Hmm.
and you have to pay close attention to Section 69, which gets into all the rules around unsolicited electronic communication, like marketing emails.
Yeah.
There are stricter rules there about getting consent and giving people a way to opt out.
So hotels really need to be careful about how they're building those marketing lists and sending out promotions. Proper consent and clear opt-out mechanisms, those are key.
Absolutely. Okay, so we've talked about what the hotel has to do, but what about the guests? What rights do they have under POPIA?
Yeah, let's switch perspectives.
All those rights are laid out in Section 5.
Mhm.
Big one is the right to be informed. If you're collecting their information, they have a right to know about it. And if there's a data breach, if someone gets unauthorized access to their data, they have a right to be told about that too.
Okay, so transparency is crucial. What else?
They also have the right to access the information you hold about them. They can ask to see it. And if something's wrong, if it's inaccurate, out of date, or if you don't have a valid reason to keep it anymore, they can ask you to correct it, delete it, or destroy it.
Makes sense. Seems like hotels need to be ready to handle those requests and have systems in place to do it properly.
They do. And it's not just about access and correction. Guests can also object to you processing their information if they have a legitimate reason. And if they think their rights have been violated, they can file a complaint with the information regulator, even take legal action in some cases.
Wow, okay. So the guests have real power here, real teeth to enforce their rights.
They do. Now, going back to those 8 conditions, the first one we mentioned was accountability. What does that actually mean for a hotel, practically speaking?
Yeah, break that down for us.
Accountability, that's the big one. It means that the hotel, as the responsible party, is ultimately on the hook for making sure all 8 of those conditions are met. You can't just pass the buck to some third-party provider. The final responsibility rests with the hotel.
Got it. So you can delegate tasks, but not responsibility.
Exactly. Now, the second condition was processing limitation, covered in sections 9 through 12. Lots to unpack there.
Lay it on us.
First off, you need a valid reason to process any personal information. It can't be arbitrary. That reason could be that the guest gave you explicit consent, or maybe it's necessary to fulfill a contract you have with them, like their booking. You might have a legal obligation to process the data, or it could be in the legitimate interest of the hotel or a third party.
Okay, so like security cameras.
Exactly. Using cameras for safety and security, that's a legitimate interest. But even then, you have to balance that interest against the guest's right to privacy. So hotels need to be clear on why they're collecting each piece of data and make sure they have a valid reason.
And document it, right.
Definitely. Keep good records. Now, POPIA also says you should try to get information directly from the guest whenever possible. And you need to be prepared for them to say no to you processing their data if they have a good reason.
So you can't just assume you can use their data however you want.
Nope. Now, the third condition is purpose specification in sections 13 and 14. That was pretty straightforward.
Yeah, it seems like it's all about being clear about why you're collecting data.
Exactly. You have to collect personal information for a specific, clearly defined, and legitimate purpose. And you have to tell the guest what that purpose is when you collect their data. That ties back into openness, which we'll get to later. For a hotel, valid purposes could include things like processing reservations, billing guests, providing services they've requested, or managing loyalty programs. No data collection without a clear reason related to your business.
So no just hoovering up data just in case you might need it someday.
Nope, that's not how it works. And once you've collected data for a specific purpose, that limits how you can use it later on. That's the fourth condition, further processing limitation in section 15.
Okay, so you can't just decide to use that data for something completely different down the line.
Right. Any further use of that information has to be compatible with the original reason you collected it. And section 15 actually gives you some things to consider when you're trying to figure out if a new use is compatible.
Like what?
Things like the nature of that new use, how it might affect the guest, and what safeguards you have in place. So for instance, say you collected a guest's email address to confirm their booking.
Uh-huh.
Using that email to send them promotions later on, that might be okay if they agreed to receive marketing emails or if they have a clear way to opt out. But selling that email address to some random marketing company, that's probably not going to fly.
Yeah, that makes sense. There are some exceptions though, right?
There are. If the guest consents to the new use, or if it's required by law, or if it wouldn't negatively impact them in any way. So it's not a hard and fast rule, but you got to think carefully.
All right, so bottom line. Be upfront about why you're collecting data and stick to those reasons unless you have a good justification and you've informed the guest.
Exactly. Now moving on to information quality. Section 16. This one's pretty common sense for any business.
Yeah, seems like it's all about having accurate information.
It is. Hotels have a responsibility to make sure the personal information they hold is accurate, complete, and not misleading. This is important for POPIA, but it's also just good business practice. You want to make sure you're billing the right person, that you have the right contact details in case of an emergency, all that.
Yeah, bad data can lead to all sorts of problems.
Definitely. And keeping your data clean can actually make your operations smoother and more efficient. Less errors, less confusion.
Okay, so information quality is about accuracy and completeness. What about openness? That's the next one. In sections 17 and 18, what's that all about?
Openness is all about being transparent with your guests. You have a duty to tell them when you're collecting their personal information.
And what do you have to tell them?
Why you're collecting it, the hotel's contact details, whether giving you that information is optional or mandatory, and what happens if they choose not to provide it. All that's got to be clear. Having a privacy policy on your website, having information readily available at check-in, those are good ways to show you're being open.
So good communication is key here.
It really is. Builds trust with your guests. All right, next up is a big one, security safeguards. That's covered in sections 19 to 22. This is where things get serious, especially with all the data breaches happening these days.
Yeah, this is a huge concern for businesses.
And for guests. So POPIA says hotels have to take appropriate technical and organizational measures to protect the personal information they hold. Basically, you got to do everything reasonable to prevent data from being lost, damaged, access without authorization, all that.
So what kind of things are we talking about here?
Well, you need a secure property management system with strong passwords and access controls, encrypting sensitive data, both when it's stored and when it's being transmitted. Firewalls, up-to-date antivirus software, all that good stuff.
And it's not just about technology, right? There's the human element too.
Absolutely. You need to train your staff on data security, have clear policies in place, and have a plan ready to go if a breach does happen. Section 21 also talks about those third-party providers we mentioned earlier, the operators. You need contracts with them that legally obligate them to have the same level of security you do.
So you can't just outsource the risk.
Right. And if a breach does happen, Section 22 says you have to notify both the affected guests and the information regulator. So you can see, having strong security safeguards is crucial, not just to comply with the law, but to protect your business and your reputation.
Absolutely. It's damage control before you even need it. All right. The last condition is data subject participation in sections 23 to 25. We've already talked about some of the rights guests have, so how does this add to that?
It basically reinforces those rights. It says guests have a right to access their data, to ask for corrections or deletions, and hotels need to have systems in place to handle those requests efficiently and within the time frames POPIA lays out. It's all about showing respect for your guests' rights.
Okay, so those are the 8 conditions. It's a lot, but they all work together. It's about creating a culture of data protection in your hotel.
Right. And it's not just about avoiding fines. It's about building trust with your guests and running a better business. Now, let's touch on a special category of data, special personal information. Section 26 and onwards deal with this. What makes this type of information different?
Yeah, what's so special about it?
This is data that's considered really sensitive and needs extra protection. In a hotel, this could be things like health information. Say a guest tells you about a medical condition they have that requires special accommodation.
Okay, so sensitive stuff.
Or biometric data, if you're using that for things like access control. Now, generally, you're not allowed to process this kind of information unless you have a specific reason that's allowed under the law.
So it's basically off limits unless you meet certain exceptions.
Right. Those exceptions are listed out in sections 27 to 33. It could be that the guest gives their explicit consent, or maybe you need it for a legal claim. There are exceptions for public health reasons and for healthcare providers, but those are very specific situations with strict rules.
And Section 33, that talks about keeping health information confidential, right?
Exactly. So the bottom line is, be extremely careful when it comes to special personal information. Only collect it if you absolutely have to, and make sure you have a rock-solid legal reason for doing so.
All right, good advice. We talked earlier about the information officer. Section 55 lays out their duties. What are some of the key things they're responsible for in a hotel?
The information officer, they're like the captain of the data privacy ship. They develop and implement the hotel's POPIA compliance framework. They're the point person for guests who have questions or requests about their data. They make sure staff are trained on data protection. Basically, they're responsible for making sure the hotel follows the law. Seems like a pretty demanding role. It is. They need to know the law inside and out, but they also need to understand how the hotel operates. Now, are there ever times when a hotel needs to get special permission from the information regulator to process data?
That sounds like prior authorization.
You got it. Sections 57 to 59 cover that. There are certain types of processing that require you to get the green light from the regulator before you can go ahead.
Okay, so like what?
Things like using unique identifiers, like ID numbers, to link different records, processing information about criminal behavior on behalf of someone else, credit reporting, and transferring personal information overseas to countries that don't have strong data protection laws. Those all require prior authorization.
So hotels need to be aware of those special cases and know when to reach out to the regulator.
Absolutely. Now, we've covered a lot about the general rules of POPIA, but what about specific guidance for the hospitality industry? Are there any codes of conduct we should know about?
That's a good question.
Chapter 7, Sections 60 to 68, give the information regulator the power to create codes of conduct for different industries. These codes basically provide more tailored guidance on how POPIA applies in specific sectors.
So is there one for hotels?
Not yet, but there could be in the future. It's something to keep an eye on. A code of conduct for the hospitality industry would be really helpful in giving hotels clear, practical advice.
Agreed. Now let's say a guest believes their privacy has been violated by a hotel. What can they do?
Well, they have the right to file a complaint with the information regulator. That's all detailed in Chapter 9, Sections 74 to 80, and some amendments to PIA. If a guest thinks their rights have been violated, they can submit a formal complaint, and the regulator can investigate.
And what about the hotel? What happens if they don't comply with POPIA?
That's where the penalties come in. Chapter 11, Sections 100 to 109, cover all the offenses and penalties under POPIA. There are specific offenses like obstructing the regulator or breaching confidentiality.
And fines.
Absolutely. Section 109 talks about administrative fines, and they can be pretty hefty. The amount depends on a bunch of factors, like how serious the violation was, how many people were affected, the potential for harm. The idea is to make non-compliance really hurt, to incentivize hotels to take this seriously.
Makes sense. So we've really gone deep on POPIA today. It's clear this is a big deal for hotels, and it's about a lot more than just avoiding fines. It's about doing business ethically, responsibly, and building trust with your guests.
I think that's a key takeaway. POPIA compliance, it's not a burden. It's an opportunity to improve how you operate, to protect your guests, and to build a stronger, more sustainable business.
Exactly. It's about creating a culture of data privacy in your hotel, not just ticking boxes on a checklist. And I think it's also important to remember that data breaches are becoming more and more common. If you can show your guests that you take their privacy seriously, that you're protecting their information, that can be a real competitive advantage.
Absolutely. It's about differentiation in a crowded market.
So here's a final thought for everyone listening, especially those in charge of hotels and hotel groups. Think about all the data your hotel handles every day. Guest names, contact details, payment information, all of it. How are you going beyond the bare minimum of compliance and turning your data practices into a real strength? Something that builds trust, streamlines your operations, and sets you apart from the competition. That's something to really consider.
I encourage everyone to dig into the details of POPIA and see how they can apply its principles in their own hotel. It's not just about following the law, it's about making your business better.
Well said. Until next time, happy diving.
See ya.